A mortgage foreclosure action is going to begin with the filing of a lawsuit, a complaint for mortgage foreclosure. Every party that has an interest in the lawsuit will have to be served with a summons and complaint. That will have to be accomplished by either the sheriff or an independent licensed process server. That's the point where you're given legal notice of the pendency of the foreclosure action, and it's very important that you contact a lawyer within 20 days of receiving that summons and complaint. Under the rules of civil procedure and state law, you have 20 days to file an answer to that complaint. So again, it's very important to consult with a lawyer to find out what your options are. With regard to that first step, we never charge for an initial consultation. Consultation can be done in the office or by telephone. Usually takes between a half an hour and an hour. And you really don't have to bring any materials, just yourself. We'll be able to ask the questions that you should be able to answer to point us in the right direction in order to develop a strategy. The next part of a mortgage foreclosure action involves filing an answer, filing a response to the complaint. The next step in a mortgage foreclosure action involves filing a response, a written response, a formal response to the mortgage foreclosure complaint. A lot of times that response will be procedural, a motion to dismiss. That will give you some time to catch your breath. We can find out the facts of the case by sending discovery on the plaintiff, asking them what the facts of the case are from their perspective. Again, that gives the client some time to catch their breath, find out what their strategy is going to be, what the facts of the case are, and how they can put themselves in a position to best resolve the case, either through getting back current with the mortgage company or letting the property go back to the bank, moving out and moving on. The litigation process in a mortgage foreclosure case can last anywhere from a year and a half to 2 years, realistically speaking. Depositions might be taken. There will be court hearings, a motion for summary judgment where the plaintiff will try to establish the debt based upon affidavits. If that doesn't work, then the court will set it for trial. Usually these items don't linger on the docket for more than 2 years. There's a lot of pressure on the bar, the judges, and the courts to move these things along without clogging up the dockets. There are a lot of foreclosure cases pending in all of the courts around Florida, and a number of initiatives have been put forward in order to help move cases along quicker. So a realistic time frame is usually about a year and a half to 2 years. Sometimes each case is unique. Factors may increase or decrease that amount of time. Usually the filing of an intervening bankruptcy case will extend that time, could allow up to another year and a half to 2 years. If a case goes to trial or a judgment is entered based upon summary judgment, the court will enter a judgment which establishes the amount owed and directs a sale in order to satisfy those amount owed. It's a proverbial sale on the courthouse steps, which is actually done on the internet now. And it's an auction sale. The result of that auction will be a certificate of sale and a certificate of title. It's very, very important to understand the deadline which occurs when a certificate of sale issues. When a certificate of sale issues, a borrower's right of redemption under state law expires. That is the point of no return in a mortgage foreclosure action. That is the point where you cannot fix it with the mortgage company, you cannot pay off the indebtedness, you cannot reinstate your loan, you cannot work out a mortgage modification with the mortgage company, and very importantly, you cannot file a bankruptcy case in order to take advantage of federal consumer protection laws which help you deal with this type of debt.